the matter of TAPAS Kumar PALIT versus State of Chhattisgarh, the Supreme Court released the appellant on bail while also observing that we do not undermine the seriousness of this matter. The case of the prosecution was that the appellant was traveling in a vehicle and police had information that the vehicle was to pass by and the same was carrying articles ordinarily used relating in the Naxalite activities. Accordingly, the vehicle was intercepted and the search was undertaken and following items were recovered from the car alleged to be in conscious possession of the appellant. 95 pair of shoes, green, black printed cloth, two bundles of electric wires of 100-meter LED lens and walkie-talkie and other articles. The appellant was arrested on the very same date, which is 24th March 2020, and the trial is in progress. Till this date, the prosecution had been able to examine 42 witnesses. The prosecution intends to examine as many as 100 witnesses. The court said that we are conscious of the order passed by us, taking the view that once the trial commences and the witnesses are being examined, then in serious crimes like murder, dacoity, rape, etc., the court ordinarily should not exercise its discretion for the purpose of grant of bail, more particularly looking into the evidence which has come out on the record. However, in this case, he has no other antecedents. It's now been 5 years that he is in judicial custody. The counsel appearing for the state has no idea as regards the time likely to be consumed to complete the recording of the oral evidence. Many times we have made ourselves very clear that howsoever serious a crime may be, the accused has a fundamental right of speedy trial as enshrined in Article 21 of the Constitution. We would like to observe as to why the public prosecutor wants to examine 100 witnesses. Who are these 100 witnesses? We are aware that it is public prosecutor who could be said to be in charge of the trial, and he has to decide who is to be examined and who is to be dropped. But at the same time, no useful purpose would be served if 10 witnesses are examined to establish one particular fact. Therefore, such results in the indefinite delay in conclusion of the trial. It is expected of the public prosecutor to wisely exercise his discretion in so far as examination of the witnesses is concerned. Where the number of witnesses is large, it is not, in our opinion, necessary that everyone should be produced. Referring to the case of Malak Khan versus Emperor, the Supreme Court observed it is no doubt very important that, as a general rule, all crown witnesses should be called to testify at the hearing of the prosecution. But important as it is, there is no obligation compelling counsel for the prosecution to call all witnesses who speak to facts which the Crown desires to prove. Ultimately, it is a matter for the discretion of the counsel for the prosecution, and though a court ought and no doubt will take into consideration the absence of witnesses whose testimony would be expected, it must judge the evidence as a whole and arrive at its conclusion accordingly, taking into consideration the persuasiveness of the testimony given in light of such criticism as may be leveled at the absence of possible witnesses. The role of special judge NIA would also assume importance. The special judge should inquire with the special public prosecutor why he intends to examine a particular witness if such witness is going to depose the very same thing that any other witness might have deposed earlier. We may sound as if laying some guidelines, but time has come to consider this issue of delay and bail in its true and proper perspective. If an accused is to get a final verdict after incarceration of 6 to 7 years in jail as an ultra trial prisoner, then definitely it could be said that his right to have a speedy trial under Article 21 of the Constitution has been infringed. The stress of long trials on accused persons who remain innocent until proven guilty can also be significant. Accused persons are not financially compensated for what might be a lengthy period of pre trial incarceration. They may also have lost a job or accommodation, experienced damage to personal relationships while incarcerated, and spent a considerable amount of money on legal fees. If an accused person is found not guilty, they have likely endured many months of being stigmatized and perhaps even ostracized in their community and will have to rebuild their lives with their own resources. We would say that delays are bad for the accused and extremely bad for the victims, for Indian society, and for the credibility of our justice system, which is valued. Judges are the masters of the courtrooms, and the Criminal Procedure Code provides many tools for the judges to use in order to ensure that cases proceed efficiently. The appeal was allowed, High Court order set aside, and the appellant was directed not to enter into the revenue limits of District Kanked, State of Chhattisgarh. He shall appear online on each date of the hearing before the trial. It is only in the last, when his further statement under Section 313 of CRPC is to be recorded, he shall personally remain present before the trial court. Also, if the conditions of bail are violated, it shall be automatically cancelled.